now pleased to hand over to Aparna Rao and Rebecca Penfold. Aparna.
Thank you, Andrew. Hope everyone can see those slides there. Good afternoon, and thank you all for joining us today for this webinar, for staying on to see us after Deanna's amazing talk just now. This is a new area for everyone, protesting under lockdown. It's something that exploded in the last 2-3 weeks. And we're going to do our best to give an overview of the law and how it might work in practice. But before we get into the law, I'd like to ask you to have a look at some quotations. You might recognise some of them. The first, please, I can't breathe. Second, we are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly. Then, there is no them, only us. And finally, what the world needs now is solidarity. With solidarity, we can build a better world. Now, think about the anti-racism protests. Each one of these quotations might be about those protests, about protesting. They might be about racism, inequality, the way human beings treated each other in the past, yesterday, the way we treat each other today, and the way we might treat each other tomorrow. Now think about COVID-19. Each one of these quotations might be about that virus. They might be about a pandemic, a terrifying force that sweeps the world. It steals our breath. It leaps from person to person. At the moment, we have no cure. So, where are these quotes really from? Well, the first one we all know, George Floyd. The second one, you might know the first line of it better. Injustice anywhere is a threat to justice everywhere. And that was, of course, Martin Luther King Jr. And he's talking about justice and injustice and the fact that we are all connected throughout that. If injustice happens to me, it happens to everyone else. But if I'm infected by a disease or a virus, that affects everyone else as well. The third quote, when it comes to global health, there is no them, only us, one of the taglines of the Global Health Council. And finally, what the world needs now is solidarity. With solidarity, we can beat the virus and build a better world. And that came from the UN Secretary General not long ago. Now, the point of these is to show how interconnected these two topics are, how similar they are in terms of their motivations, the way they challenge the state and they challenge our legislative capabilities. How do we deal with both entrenched societal problems and an as yet undefeated disease? The impact of this disease on the world is plain to see. Nobody wants more deaths, prolonged economic damage, all its cascading consequences. And nobody wants an infringement on the right to protest in a democratic society. We recognise what George Floyd's death has meant and the undeniable problems it's highlighted around the world, and indeed the impact that we've recently been seeing. And as lawyers, we know the inherent tension between what we feel is politically or personally right and wrong, and on the other hand, what the law is. There are no two topics at the moment that are more emotive than these two. And you'll find arguments for and against the law elsewhere, not today. You'll find people who will firmly feel that nothing can or should be allowed to restrict protest rights. And you'll find others who cannot see how the freedom of assembly outweighs the risk to the global pandemic. And we're not answering that here. What we've tried to do is put some of this natural emotion to one side for the purpose of getting down to the bottom of what the law is. So, we're going to go through European Convention on Human Rights, couple of the rights and limitations that have been affected, particularly Articles 10 and 11. Rebecca will then talk to you about the police powers and the lockdown laws that are in place at the moment and how that affects protesting, and then she'll look at some of the offences that might arise. I'll conclude with some defences and then pass back to Rebecca for some thoughts and to take any questions. A quick note on overview on terminology. We'll be referring to COVID regulations, which are effectively those restriction regulations. There is also the Coronavirus Act and, of course, as I've mentioned, the European Convention on Human Rights. But when we say COVID regs, we mean those restrictions. Now, the European Convention on Human Rights, many of you will be very familiar with the way it's set out and the way that the freedoms within it are usually qualified. There are only a few absolute rights. Many of the non-absolute rights have found themselves in a place where I don't think any of the drafters ever thought they would end up. The one exception to that is Article 5, the right to liberty, and that was qualified by the need to detain people to prevent the spreading of infectious disease, and that was anticipated, but that's the only one. Some of the other rights that have been curtailed, and I would suggest probably accidentally, are very significant indeed. Now, when we come to discuss protesting and the rights to freedom of expression and freedom of assembly, those are extremely significant rights and have correctly been in our focus for the last few weeks. But it's important to remember, and I would suggest is likely to be relevant consideration for any court considering restrictions on Articles 10 and 11, that several other significant rights have been qualified or done away with altogether. As an example, any criminal practitioners here will know the right to a fair trial, qualified, or in some cases it's just not happening at the moment. Reasonable time, are we hearing trials within a reasonable time? Are hearings effectively in private rather than in public, on phone and on video, where members of the public can't attend court, can't dial in, or if they can, they don't know how, etc. The defendant is supposed to have adequate time and facilities for the preparation of his defence. Well, we can't visit our clients in prison at the moment. There are no secure, privileged phone lines for conferences. Witnesses can't attend court. We're getting their evidence in different ways. Interpreters are difficult to get hold of and have on video links so that we can have conferences with them and talk to them, prepare defences and so on. So Article 6 rights clearly qualified by COVID and by various regulations. Freedom of thought, conscience and religion. Well, until a couple of days ago, you couldn't go anywhere to manifest your religion or your practice. You had been limited in doing that. You could perhaps watch Zoom or video conferences of a priest or a minister in a church performing a ceremony, but you couldn't go and exercise those rights. Again, they were qualified because of the need to protect public health and safety. Right to marry. You can't get married or form a civil partnership in England at the moment. You can't found a family if you're, for example, relying on IVF, though clinics have only started reopening in the last few weeks, and most of them still aren't open. The implications of not being allowed to marry and not being allowed to have a child are vast. And the right to education, we know schools have been closed. I note briefly Article 15, derogations. Derogation in the time of emergency has been invoked by several countries during the COVID-19 crisis, but the UK hasn't done so. Now, we come on to the articles that govern protest rights, and I've spent some time going through the other rights because context is everything. If a court has to decide whether an interference with protest rights is necessary and in pursuit of a legitimate aim, the fact that so many other rights have also been interfered with is going to be relevant, as is the fact that some of the interferences of some of those rights has been reduced and others haven't. And I'm not here to say whether this is necessarily legitimate or not, but a court is likely to find the broader picture extremely valuable when it comes to assessing whether Articles 10 and 11 have been illegitimately restricted. Now, Article 10. This is effectively freedom of speech, freedom of expression. Hold opinions, receive and impart information and ideas without interference. So we're free to express our views about, discuss racism, inequality, and the consequences of those. There are the exceptions to that, because it's a right that carries with it duties and responsibilities. So the protection of public safety, for example, protection of health, and the protection of rights of others. And so if we are concerned with protecting the rights of others, for example, the right to life, health, we need to balance the risk of spreading a disease with the right to freedom of expression. Article 11 is really the biggest hit in terms of protests, because peaceful assembly is that physical act of going somewhere with other people to make a point peacefully. And again, public safety, protection of health, protection of rights and freedoms of others. So we'll come back to some of that when we look at defences a bit later on. But this establishes the idea that a peaceful protest can, in certain circumstances, limit someone else's rights and freedoms, for example, and can be a reason to restrict Article 11. So that's the framework of the rights to protest. And I'm now going to pass over to Rebecca to speak about the powers that the police have in respect of our exercise of these rights.
Thank you. So moving on then to what powers the police have in protest situations. Well, these powers were in place before COVID-19 hit, and they continue to be in force. And you can see them there on the slide. So PACE, the Police and Criminal Evidence Act of 1984, created the legislative framework to protect both the police and the public when the police exercise their powers. And those details listed there we will consider further on in the presentation, but for now I want to focus on one of the tactics that has reached the news recently, and that is the tactic of kettling. This is done to control large crowds by physically containing people. Despite legal challenges, this is a lawful police tactic. And in recent weeks, we've seen quite a contrast with how protests have been policed around the country. In Manchester, Greater Manchester Police have not used kettling as a tactic, whereas in London, the Met Police have. And there's a real concern as to the appropriateness of this tactic in times of COVID. And of importance for us is the case listed there of Mengesha, and that held that containment is not permissible for any purpose other than to prevent a breach of the peace, which is taking place or reasonably thought to be imminent. And in particular, it is not permitted as a means of ensuring that the identification of those contained is obtained. And there's quite a lot of discourse at the moment as to whether the Met Police have misused their powers in respect of this in recent weeks. So moving on now to focus on PACE. Aparna, can you move the slide along, please? Thank you. Stop and search powers are found in section 1, and that is when an officer has reasonable grounds to suspect that the individual is carrying drugs, weapons, stolen property, or something that could be used to commit a crime. And now this applies to both protest and non-protest situations alike. The police can also stop an individual, ask for their details, but there's no positive obligation in law to comply with that. However, providing false details could lead to an obstruct charge. But the police do have the power to require details from someone, and that's under section 50 of the Police Reform Act of 2002. But the police can only lawfully exercise this power if they hold a genuine and reasonable belief that the individual has been engaged in antisocial behaviour. And that's behaviour defined as causes or likely to cause harassment, alarm or distress to one or more persons not of the same household. The arrest powers, as standard, are found in section 24 of PACE, and that's when the constable can arrest without a warrant if they have reasonable grounds for suspecting one is or is about to commit an offence, or anyone who is in the act of committing an offence. And we will see later on that this power has been extended by the COVID regulations. Moving on now then to please consider the Criminal Justice and Public Order Act of 1994. Now this is the next set of police powers for protests, and it gives wide powers relating to assemblies. Section 60 Authorization allows the police to stop and search anyone or any vehicle within a specified area and time frame without the requirement for suspicion or reasonable grounds that is ordinarily found in Section 1 of PACE. Now, things have moved on since we wrote our article a couple of weeks ago and since the first set of protests. The weekend just gone, weekend of 13th and 14th of June, saw the Met Police use their powers under Section 60. So let's have a look at the wording of Section 60. And it's set out there on the slide for you. Now, in our view, when looking at Section 60, it appears to us that the Met would have relied upon subsection A when seeking the authorisation that they did for last weekend, in that they had reasonable belief serious violence may take place. And we think that because Met Police Commander Baz Javid stated in the Met News announcement of the 13th of June the following: "Whilst we believe there is no imminent threat to the public, we will not tolerate any violent disorder like we saw last weekend." And what then follows with the Section 60 authorisation, next slide please, Aparna, is a Section 60 AA order. Now, this automatically applies if a Section 60 authorisation is in place. This is important. It gives the police the power to require an individual to remove and surrender any item which the constable reasonably believes that person is wearing wholly or mainly for the purpose of concealing their identity. Now, this is of particular interest in the COVID-19 world, wearing a face mask. Wearing a face mask whilst at a protest may have a very different and legitimate purpose. However, seemingly the law has not been amended to take account of this. Moving on, please, Aparna, to the next slide, considering the conditions on processions and assemblies. This is where the Public Order Act of 1984 comes in and gives the police further powers. Under Section 12 and 14 of the Act, conditions can be imposed such as the number of people involved, location and duration. But before we move on to consider Section 12 and 14 in more detail, it's worthwhile also considering the Section 35 dispersal power that's listed on the bottom bullet point there. That power was found in the Anti-Social Behaviour, Crime and Policing Act of 2014. And the police can obtain powers of dispersal, thereby forcing people to leave an area and not return. And that is a power that the Met Police have been using at the recent protests. And the power is used in order to remove or reduce the likelihood of members of the public becoming harassed, alarmed or distressed, or the occurrence of crime or disorder in a particular area. And if you return, you can be arrested. So if we focus now on Sections 12 and 14 of the Public Order Act, we can see there on the slide there's a statutory test that applies, and it's the same test that applies to both Section 12 and 14. Now, Met Police Commander Baz Javid made an announcement on Friday the 12th of June in anticipation for the protests last weekend, and he referred to the protests that had happened the week before, saying the following: "There was a minority intent on disorder which resulted in incidents of violence and criminal behaviour and assaults against our officers." So when looking at that test set out there on the slide, it appears to us that the Met have relied upon subsection A when seeking the conditions that they sought for last weekend. And we're going to look at this in a bit more detail when we consider in a few slides' time possible defences to COVID regulation offences. So let's move on now to what we call the lockdown laws. And the most important one for our purposes today is the health protection regulations as set out there. And it's worth noting that the lockdown laws vary throughout the UK. This is the law as applicable in England, and it changes frequently. Relevant to us now are Regulations 7 through to Regulation 9. And Regulation 7 creates that restriction on gathering, which is defined there as a social interaction or other activity. And in short, Regulations 7 and 9 criminalise gatherings of 7 or more people outdoors, unless an exception in paragraph 2 of Regulation 7 applies. And we'll consider those exceptions now in the next slide. So they're set out there. And what is perhaps interesting is the final exception there, letter F. Considering that last exception, we think it's unlikely that it could be argued that protests would fall into this exception, where a gathering is lawful where it is reasonably necessary for the purposes of education. However much one would argue that public education is needed on the issue of racism, as the gathering must take place at an educational facility. So moving on to consider Regulation 8, the enforcement. This sets out what the police can do if they consider Regulation 7 as being contravened. They can direct a gathering to disperse, they can direct any person to return to the place where they live, they can remove any person to return to the place where they live. They may use reasonable force. They may only exercise this power if it's necessary and proportionate to ensure Regulation 7 compliance. And they can give any reasonable instructions that they consider to be necessary. And at this stage, it's probably important for us to say that we would encourage all to read the regulations carefully. There is no substitute for that, especially now when these regulations change so often, and there is no case law interpreting them. The wording of the regulations is all that we have. And specifically, these regulations do not stop groups of people, less than 7 people, from protesting. And it's important because when we are considering whether police behaviour at protest is valid, it's important to think about which power the police are using. Is it PACE? Is it the Police Reform Act? Is it the Public Order Act? Or is it under the COVID regulations? So Regulation 9. For our purposes, Regulation 9 is effectively what criminalises gatherings of 7 or more people. It provides a defence of reasonable excuse, and it widens the arrest powers under Section 24 of PACE, in that the reason for arrest can be to maintain public health or public order. And note again here, the physical and social distancing guidance or guidelines is just that. It is not in the legislation. At no point in this legislation is there any comment as to the 2-metre rule that is often spoken of. Moving on, please, then to the Coronavirus Act 2020. We think it's worthwhile raising that this Act exists, at the very least, because multiple instances of the police and the CPS wrongly charging offences under this Act under Schedule 21. And you can see on the slide there, paragraph 23 of Schedule 21 only relates to potentially infectious people and then criminalises certain behaviour. So if you're at court or at the police station, when considering a potential charge or in fact a charge at the court, in the words of Boris Johnson, stay alert. Schedule 22, we've put this up so that you're aware of it. It's an interesting provision. We've yet to see it in practice, and we do not know if it will be of use in regards to limiting protests, but it's useful to be aware of. So what potential offences do we think are in play in protest situations in COVID-19? In our view, one is more likely to fall foul of the normal offences that apply to all protests. So obstructing an officer, failure to comply with police orders, public order offences, criminal damage. Police have not really been using their powers under the COVID laws, but it's worthwhile noting that the relevant offences would be found in Regulations 7 and 9 of the coronavirus regulations. What the police tend to do is tag on an extra offence under the coronavirus regulations. Moving on then. So Commander Baz Javid, he's getting quite a lot of mentions in this talk today. He made an announcement on the 12th of June 2020 saying the following. The Met's primary position regarding any gatherings on Saturday the 13th of June is that participation in these protests will be in breach of Regulation 7. The decision that has been taken to impose conditions under the Public Order Act does not mean that the protest is authorised by police. So the Met imposed conditions under Section 12 and 14 of the Public Order Act. If we then look at Regulation 8, which is on the right-hand side of that slide, we can see that it looks like the police might have a power to prohibit protests as a step necessary to enforce the lockdown regulations. I also note at this stage that Section 13 of the Public Order Act does allow for a blanket prohibition on protesting. If the police really wanted to stop the protest, so what they would need to do is have reasonable belief that a Section 12 power wouldn't be sufficient to prevent the protest resulting in serious public disorder. So if Commander Javid says participation in a protest is in breach of the COVID regulations, and the state is actively seeking to prevent the spread of COVID-19 by keeping us in lockdown at a particularly key point in this pandemic, then why do they not just rely upon Regulation 8? And our next thought that flows from that is whether Regulation 8 should even be used in this scenario. The powers already exist in the Public Order Act. So in our view, Regulation 8 shouldn't be used for that purpose when it already exists in legislation elsewhere, unless perhaps it could be demonstrated that such an existing power couldn't be reasonably used. So in our view, contrary to what Bas Javid said on the 12th of June, it can be implied that because the Met imposed conditions under the Public Order Act on the protests and did not prohibit them, so long as the protesters complied with those conditions and protested peacefully, the protest might well be legal. And we will see that this is not the first time that public statements have been made that are entirely contradictory and confusing. But how in reality can that help us as criminal practitioners? Well, thinking of the COVID offences, does the fact that the protest hasn't been prohibited by either Regulation 8 or Section 13 create a legitimate expectation that one won't receive a fixed penalty notice for breaching the regulations, one won't be arrested for breaching the regulations, or could it be a defence of reasonable excuse? Or, so long as Section 12 and 14 conditions are complied with and there's a peaceful protest, would it then be disproportionate and contrary to the public interest test to even charge a breach of the regulations? Further, does the fact that the conditions in place demonstrate an acquiescence by the Met that the right to protest is more important than compliance with COVID regulations? And it's worth thinking about these until and unless there is a test case. Aparna is now going to look at the potential defences to these offences in more detail.
Thanks, Rebecca. Well, are there any defences, particularly to the COVID offences? There's, of course, the sort of standard type. Well, it was unintentional. I was going from A to B and a protest was in the middle and I accidentally got swept up in it. I was kettled. I couldn't get away. My accidental involvement means that I didn't intend to be part of this gathering, and we think that would be the kind of reasonable excuse that might well arise in this scenario. But more interestingly is whether it's a reasonable excuse that one wants to protest, that one wants to exercise one's rights under Articles 10 and 11. And of course, this hasn't been litigated. There are arguments on both sides. There are other ways of protesting. There are the difficulties involved in gatherings, large gatherings, the way that the virus is transmitted. Equally, it is extremely important not to stop people from expressing their views, particularly, for example, if they wanted to express their views against COVID regulations, which isn't the case in this particular scenario, but one could see how that might arise. One of the useful cases on this is Ziegler, but note it is, I understand, being appealed, at least that's the way it's marked at the moment. And that case concerned the offence of obstruction of a highway by protesters whose defence was that they were exercising lawful rights under Articles 10 and 11. And the point from this case is that it's very clear, at least at this level of the appellate procedures on this case, that we have to strike a fair balance between the rights of individuals to protest and the general interest of the community. And in this particular case, the right to use the highway that was being blocked by the protest was something that the court held the district judge had got wrong. His assessment about proportionality was in all the circumstances wrong. And so we would argue that as a matter of law, it's unlikely that a court would find that exercising rights to protest in breach of Regulation 7, that is a Reg 9 offence, would strike a fair balance with the general interest of the community, given what we know about COVID and the way that it spreads. But watch this space. We don't really know what the answer is even to this case, which predates COVID, and we certainly don't know what's going to happen if someone decides to either ban a protest or prosecute someone for taking part in a peaceful protest, and then whether that gets past the magistrate's court and then whether it gets to appeal. But you might be thinking, well, all that law is all very well, and yes, we could argue all kinds of highly technical and interesting human rights points in front of higher courts and come up with some abstruse and extremely well-reasoned judgment. But isn't the fact of the matter that if the Prime Minister says I can protest peacefully, I've got a reasonable excuse for breaching Regulation 7? And so before the first wave of protests, the Prime Minister said to us, people have the right to protest peacefully and whilst observing social distancing. He distinguished that from violent protest. Now, of course, observing social distancing isn't in the law, so it's neither a breach of the law not to socially distance, nor is it a defence that you have socially distanced. Although in specific cases, perhaps you might be able to argue that that means you weren't in a gathering. So that was the one view we had, and that was on the night of the 7th of June. But the fact that Boris said I could protest peacefully isn't really enough. The Home Secretary said I couldn't. The very next day, she told Parliament that in normal circumstances, the government would not oppose peaceful protest, but that due to coronavirus, it is illegal to hold large gatherings. She hasn't read what the PM tweeted, and one might want to query how she would, in normal circumstances, attempt to oppose peaceful protest in any event. But there's certainly contradictory guidance from senior members of the government on their own legislation. Just to make sure that we didn't have a two-way argument, we then got this, and you'll see it's our first participant coming back again. Mr. Johnson then said, and this is a thread, I've picked out some of it, you can go onto Twitter and have a look at the whole lot if you want to. He's explaining, of course, fighting racism is very important, but then he says, because there's been some violence, the only responsible course of action is to stay away from these protests. And you might query whether that's a restriction on the rights of those people who want to protest peacefully alongside whoever might be breaking the law, not COVID laws, other laws, by protesting in a violent manner. So we've got contradictory information both from the Prime Minister and the Home Secretary, and then again from the Prime Minister appears to be contradicting what he said earlier. Is this of any help if you end up in the magistrates' court having been in a peaceful protest and you say to the magistrates, well, I have a reasonable excuse. The Prime Minister said it was all right. So the court will be wanting to go back to the definition of gathering that we looked at in Regulation 7 earlier. And the gathering involves people either together for a social activity or for some other activity. Now, if that phrase is ambiguous, we might be getting into pepper and heart territory. Obviously, this isn't Hansard, it's not covered by parliamentary privilege, but the fact that ministers who are responsible for the legislation give what appears to be guidance and interpretation on what it means may well be something that in this new era of Twitter and everything else, and with legislation that hasn't been scrutinised through Parliament and that has all these unintended consequences, it might well be something that a court can take into account. It might not be something that a magistrate's court will find easy to take into account. You might find that you need to go a little higher in order to make that kind of pepper and heart style argument. All right, I'm going to switch back to Rebecca to just finish off with some concluding thoughts.
So we really are in extraordinary times, and going back to the title of our article, the right to protest in times of COVID-19, is this in fact an attempt to balance the impossible? We hope we have raised some issues to consider when you represent those arrested at protests, and it's always worthwhile going back to the wording of the regulations and considering the code for Crown prosecutors. Is there a realistic prospect of success, or is it even in the public interest to prosecute? Practical tips then. These are predominantly all summary-only offences, so you have to think practically of the tribunal in which you will be presenting your arguments. So it will be the magistrates' court, and I will say nothing else on that point. But in our view, if you're unsuccessful when defending at a trial in the magistrates' court, you're likely to need to consider an appeal by way of case stated. And let's consider that reasonable excuse defence that Aparna has just considered. Your punter says, but the PM tweeted saying I could protest. We would argue that a finding of guilt having run that defence, would be such a perverse finding, and that would be suitable for case stated. At the moment, we've yet to have any of those cases come up, but it's some thoughts for us all as practitioners. And then moving on to the final slide then, may I just take this opportunity to thank 5 Paper Buildings for having me as a guest speaker on this webinar. Aparna and I would both be very happy to answer any questions you may have on this topic.
And in turn, Rebecca, thank you very much for joining us. Thank you, Aparna, as well for that talk. I don't think we do have any questions, so all that leaves is for me to thank everyone once again for joining us. We're going to take a break next week, and we'll be back on the 2nd of July with a talk by Ben Douglas-Jones, Queen's Counsel, James Marsland and Christopher Jenkins about the Modern Slavery Act and the Section 45 defence. Until then, please do stay safe and take care. Bye for now.